Hi students, I'm back with another short video lecture. This is the beginning of Unit 4 on search and seizure. Week 7 will cover search warrants, and Week 8 will be the exceptions to the search warrant. I would just highly recommend to you that you read the Fourth Amendment. It is in your book. It's not very long. It's 25 words, more or less, but it'll give you a better understanding of what we're talking about here in this unit on search and seizure. The Fourth Amendment itself is a protection from government abuse. That's how it all started. Leading up to the revolution, there were a series of abuses by King George III that what really was the impetus for the colonials having the Fourth Amendment to the Constitution. The most significant abuse by the king was the use of what we call general warrants. It was a court order. It was authorized by government officials to search and to seize with very few limitations on where they could search and what they could seize. So that was one abuse. The other abuse was the use of writs of assistance. These writs permitted customs agents to search any place where smuggled goods might be concealed, even if there was no particular suspicion the goods were even there. So these two abuses by the king led to the Fourth Amendment being proposed and ratified by the colonials. So the one of the major purposes of the Fourth Amendment was to abolish these general writs and writs of assistance. Initially, the Fourth Amendment was not litigated very much. There were several reasons for this. The first reason is that it only applied to the federal government anyway, and the federal government initially was very, very small. Secondly, law enforcement did not emerge until the mid 19th century, so it didn't emerge until say 1850s or so. And then lastly, there was no remedy even spelled out for a violation of the Fourth Amendment. So the Fourth Amendment wasn't litigated very much. The first case, uh, important case on the Fourth Amendment was the Weeks case, Weeks. It was a 1914 case, and it was a U.S. Supreme Court case, and it held that if there was a violation of the Fourth Amendment, the evidence that was seized in violation of the Fourth Amendment would be suppressed. However, this only applied to the federal government. Along came Wolf versus Colorado, another U.S. Supreme Court case, and in Wolf, the court held that the exclusionary rule did not apply to the states. Um, and then the next most important case was Mapp versus Ohio. That was a case involving Dolly Mapp. There was a search of her home by law enforcement. They did not have a warrant. They seized some items. She was actually charged with obscenity charge. And it's interesting just about the obscenity charge because we talked about obscenity in the free speech unit, right? And obscenity had to meet, remember the Miller test. So it had to appear to the prurient interest of the average person, be defined by state law, and then have no social or other redeeming value to it. And just pay attention when you watch Map because you'll soon find out that these items that she had did not even rise to the level of obscenity under Miller. So, but anyway, actually, Map Dalry Map was convicted. She appealed, and the court overturned Wolf and said that the exclusionary rule does in fact apply to the states. It's part of the Fourth Amendment. The Fourth Amendment applies to the states through the 14th Amendment. Remember, that's selective incorporation we talked about in the very first chapter, I think. Um, but the Fourth Amendment applies to the states through the 14th Amendment. The exclusionary rule is part of the uh, Fourth Amendment. It gives a person a remedy if there's a violation of the Fourth Amendment by law enforcement. That remedy is to exclude illegally obtained evidence. It also it's there to deter police misconduct. So if the police know that they're not going to get away with violating the Constitution, then they won't violate the Constitution. It's pretty straightforward and as simple as that. So the biggest question is when is there a search? When has law enforcement conducted a search? And originally, if you stop and think about it, the original definition of a search came from the colonial times, and a search occurred when there was a physical intrusion into a protected area. So the Fourth Amendment protected what? Person, their effects, their papers, and their home. So if there's a physical intrusion, say, into their home, a physical intrusion by the government into their home, that was a search. So later, the courts had to reconsider the definition of a search. Why did they have to reconsider the definition? And that was because of technology. There's a case called Olmsted. In Olmsted, a man lived in a home. He was involved in some nefarious criminal activity. The law enforcement decided to install a wiretap, and they installed this wiretap on a telephone pole across the street. So it wasn't on the property of the defendant, and it was across the street on a pole. So they were able to seize by recordings conversations of the defendant engaged in his criminal activity. He was indicted by the government. He made a motion to suppress these items, and the court said, well, they use this physical intrusion rule, or it's also called the trespass rule, and they said, well, the federal government did not trespass onto your property, so therefore your motion to suppress is denied. There's no trespass, no physical intrusion, there is no search, they did not need a search warrant, therefore your motion is denied, and they upheld his conviction. So that was the law for some time, and then along came the case of Katz. Katz was a case where the perpetrator was involved in nefarious criminal activity. He was conducting his operation. I don't know if it was drug dealing or gambling from a telephone booth. Those are the old style telephone booths. You don't see them much anymore, but they were made out of plexiglass. They had an accordion door. You can open, step into them, and shut it. Just small enough for one person. Had a payphone. Had a phone book in there. You'd pay money into this phone and make your phone call. So he's using this phone booth to conduct his criminal enterprise, and the federal agents were aware of it, and they knew the law of Olmsted, so they didn't want to conduct a physical intrusion inside of this phone booth. So they decided on the outside of the phone booth they would put a recording device, and that's what they did. They recorded him. He was indicted with some federal violations. He made a motion to suppress. So you would think that if the court followed Olmsted, there was no physical intrusion, that the motion to suppress would be what? Denied. So it would be denied. However, the court in Katz, what did they do? They actually changed the definition of a search, and they said a search occurs when the government violates a person's reasonable expectation of privacy. So did this person have a reasonable expectation of privacy inside the phone booth? Did he have an expectation that his conversation, although you could see him through the plexiglass, you could see him clearly, but did he have an expectation that his conversation would be private, that no one would be able to hear him? And the court said yes. So the court said yes, there was a search under this new test, the reasonable expectation of privacy test. Law enforcement did not have a search warrant. They needed a search warrant, and therefore they granted the motion to suppress. Interesting. Now, for a long time, when I taught this class, I taught that, well, this reasonable expectation of privacy test is the test, that Katz overruled Olmstead, and there was the trespass rule was no longer the rule. It was only the reasonable expectation of privacy test. Then along came the case of Jones. Jones was a case involving a tracking device on a vehicle. So law enforcement officers took a tracking device, they installed it on the perpetrator's car, and the car was parked on the public street. Now they were able to track this car two ways. One, they could track it real time as the car was moving. They could bring up the information on a computer, and they would know where the vehicle was going. The other way was to download the information from the tracking device to determine where the car had been earlier. So they obtained this information. This person was indicted based on that information, and he made a motion to suppress the evidence. And it went up to the U.S. Supreme Court. The Justice Scalia wrote the opinion of the court, and he said, "Hey, this is a very simple case." And he said, "This was a case where the government actually physically intruded. There was a physical intrusion on a protected property. The protected property was this man's vehicle, and when the officers touched it and installed the listening device, they physically intruded on the vehicle, and they needed a warrant to do that. And so the motion to suppress, they did not have a warrant, so the motion to suppress was granted." Scalia also said, hey, the reason when Katz came out and they announced the reasonable expectation of privacy test, that did not eliminate the physical intrusion case. It actually just added another test or another definition of a search. So in conclusion, a search occurs when there is a physical intrusion on a protected property or a person, or a search occurs when there's a violation by the government of a reasonable expectation of privacy. So if you have a search, then the officers will need a search warrant, or they're going to need an exception to the search warrant. And so the next video, we're going to talk about the requirements for a search warrant. There is actually a sample search warrant that I have there. Open it up, take a look at it, read through it. It's not very long. It's about 4 pages. It'll take you a few minutes just to take a look at it. It's a sample search warrant from Los Angeles Police Department. It's a narcotics case. There's an informant involved, but so there's a sample search warrant. We'll talk about search warrants. That's in week 7, and then in week 8, we're going to discuss all the exceptions to the search warrant. We're going to talk about consent. We're going to talk about search incident to a lawful arrest, the automobile exception, exigent circumstances. We're going to talk about the exceptions to the search warrant. Now, there's more than that, but we're going to talk about a handful of them. And again, remember, if an officer is acting with a search warrant, that search is presumed to be what? That's right, lawful. And the burden is on the defendant to show it's unlawful. So, but if they're acting without a warrant, then it's presumed to be, that's right, unlawful, and the burden is going to be on the people to establish that it was lawful. So if the officers are acting without a warrant under one of those exceptions, they're going to have to show that it was lawfully within or lawfully one of those exceptions. So, all right, so I'm going to end the video. If you heard a little background noise, I apologize for that. And anyway, I'll let you go. Stay safe, and I'll look forward to the next lecture. Take care.